He was going on a work trip with Jesus. Are they still asking, where's daddy?
Yes, my daughter continues to ask. I told her the other day, because she said, I just miss daddy, and where's daddy? When is he coming home? And I said, baby, daddy's still with Jesus.
And I talked to her and she said, Mommy, I missed you. I said, I missed you too, baby. She goes, where's daddy? What do you tell her?
Erika Kirk has just taken a step no one expected. After weeks of mounting pressure and court involvement, she has now filed a lawsuit against Charlie Kirk's parents in an attempt to regain custody of the children. But what's driving shockwaves is the claim at the center of that filing. A revelation that calls the entire family narrative into question and turns a private custody fight into a public confrontation. This isn't a quiet legal move happening behind closed doors. It's a calculated escalation that reopens every unresolved tension since Charlie's death and reframes the grandparents not as protectors, but as adversaries. The moment those papers were filed, the story stopped being about grief and became about control, identity, and who has the legal right to define the truth. And once a case like this enters the courtroom, intentions don't matter nearly as much as evidence. Because from here on out, every decision, every past action, and every claim will be dissected under oath, with consequences that could permanently reshape what remains of this family.
Why does Erika Kirk keep forgetting that she has children?
What are they going to threaten me with? Going to heaven sooner to be with my husband?
I think you could ask any mother this same question, and every mother is going to express concern about who's going to take care of the kid.
The lawsuit didn't come out of nowhere. It landed after weeks of quiet tension where custody wasn't just being debated behind closed doors, but actively questioned by the court itself. By filing against Charlie's parents, Erika shifted the fight from defense to offense, signaling that she was no longer reacting to pressure. She was trying to take control of the narrative again. At the center of this move is a claim that instantly raises eyebrows and changes the legal terrain. By asserting that the children are not biologically Charlie's, Erika isn't just challenging the grandparents' role. She's challenging their standing altogether. If that claim holds, it could undermine the very foundation of why they were considered custodial options in the first place. But making a claim like that in a courtroom isn't the same as saying it online. Once it's part of a legal filing, it demands proof, timelines, and explanations that go far beyond implication. And that's where this strategy becomes risky, because every unanswered question invites deeper scrutiny. What started as a custody dispute is now something far more explosive. And as the court begins pulling on this thread, it raises a question no one was prepared for. What else might unravel next?
Daddy's on a work trip with Jesus so we can afford your blueberry budget. What little kid isn't going to completely internalize that and be like, hey, we don't have to eat any more fruit, like blueberries, that means daddy can come home. They're immediately going to think that it's their fault for eating too many blueberries, and that's why daddy's
Once that claim entered the lawsuit, the focus of the case shifted almost immediately. Custody was no longer being discussed solely around stability, caregiving, or emotional well-being. It became a question of legitimacy. If the children were not biologically Charlie's, then the grandparents' legal footing suddenly looked very different on paper. That shift matters because family courts don't operate on emotion or history alone. They operate on documented relationships and legal standing. By introducing this argument, Erika forced the court to pause and reassess who actually qualifies as family under the law, not just in name, but in fact. But the move also opened a door Erika may not have fully controlled, because when biological claims surface, the court doesn't speculate, it investigates, records get examined, timelines are reconstructed, and once that process begins, privacy disappears fast. What was meant to weaken the grandparents' case now risks pulling every chapter of the past into the open, including moments no one ever expected to revisit. Behind the scenes, this filing reportedly stunned people close to both sides. Until now, the dispute had centered on caregiving concerns and grief management. This new angle reframed everything as a battle over truth itself, placing the children at the center of a claim they are far too young to understand. For the grandparents, the accusation isn't just legal, it's personal. Their connection to the children was built on the belief that they were preserving their son's legacy. To suddenly be told that legacy may not exist as they believed cuts deeper than any custody ruling ever could. For Erika, the gamble is enormous. If the claim can't be supported cleanly and conclusively, it risks backfiring in the worst possible way. Courts are deeply cautious when parents introduce arguments that destabilize a child's identity, especially during an already volatile custody dispute. And as this case moves forward, one thing becomes clear. The This isn't just about who gets custody. It's about whose version of reality survives the courtroom and whose doesn't. As the lawsuit unfolds, attention is starting to shift toward motive. Legal experts point out that introducing a claim this severe at this stage isn't accidental. It changes leverage, it reframes sympathy, and it places the grandparents on the defensive instead of allowing them to argue from stability and continuity. Until now, the grandparents' position was rooted in concern for the children's emotional safety after a traumatic loss. That argument resonated because it focused on the kids, not conflict. But once their biological connection is questioned, the case pivots away from caregiving and into verification, documentation, and credibility. That shift benefits one side more than the other. Courts tend to slow down when foundational facts are disputed, buying time for the parent who is under pressure. And time in custody cases can be just as powerful as evidence, but delaying resolution comes at a cost. The longer this drags on, the more uncertainty the children are forced to live with. And that's something judges rarely ignore for long. What makes this even more complicated is how late this claim surfaced. If questions about paternity existed, critics are asking why they're emerging only now, in the middle of a custody crisis. Timing matters in court, and late revelations often invite skepticism rather than sympathy. Family courts are especially cautious when a parent introduces information that could destabilize a child's identity. Judges tend to ask a simple but critical question: does this help the children, or does it help the case? And that distinction can quietly shape everything that follows. The grandparents' legal team is expected to challenge not just the claim itself, but the intent behind it. Was this about truth, or was it about eliminating competition for custody by any means necessary? That question now hangs over the entire proceeding, and once intent becomes part of the discussion, the case stops being clinical. It becomes deeply personal and far harder to control. As the court process deepens, attention is beginning to turn toward pattern rather than incident. Judges don't just evaluate isolated claims, they look for consistency in behavior, timing, and decision-making. And that's where this case becomes more complicated for everyone involved. By introducing a claim that reshapes the children's identity during an active custody dispute, Erika has forced the court to examine her broader judgment under pressure. Family courts are especially sensitive to actions that escalate conflict rather than reduce it, particularly when young children are involved. This doesn't automatically invalidate her position, but it does raise the threshold she now has to meet. The court will want to know why this information is being introduced now, how it serves the children's interests, and whether it reflects long-term planning or last-minute strategy. Once those questions are on the table, the case stops moving forward on momentum alone. It slows down, becomes more forensic, and far less forgiving. For the grandparents, this stage of the fight is about endurance rather than escalation, even if the biological claim dominates headlines and public conversation. Their legal strategy is expected to stay focused on continuity, emotional safety, and the children's expressed needs. Courts often value who has been consistent over who is most aggressive, especially when emotions begin to cloud judgment. There's also the matter of perception inside the courtroom, which often carries more weight than any argument made outside of it. Judges are trained to detect when a case is being steered by control rather than care. If the dispute begins to look like a power struggle between adults, the court may take steps to remove that struggle from the children's daily lives altogether. That's why this phase is so critical. Every filing, every statement, every delay now feeds into a broader picture of who can provide stability without escalating conflict or chaos. Small choices made under pressure can quietly shape how each side is viewed. At this point, the case isn't just progressing, it's solidifying. And whatever direction it settles into may define the outcome long before a final ruling is ever announced, leaving little room to undo early impressions. As the case edges closer to a decisive phase, the spotlight is no longer just on the claim itself, but on what happens if it fails. Courts don't treat destabilizing arguments lightly, especially when they involve a child's identity and sense of belonging. If the allegation can't be substantiated clearly, it doesn't simply disappear. It becomes a liability. At that point, the court may begin weighing whether introducing such a claim caused unnecessary emotional risk. Judges are tasked with minimizing harm, not amplifying conflict.